All right, thank you for staying with Daybreak. We're still having the discussion around the advisory from the Chief Justice to the President to dissolve Parliament for not adhering to the two-thirds gender rule. And joining us now is Steve Ogola, he's an advocate of the High Court. Steve, so what happens in the interim? Now the Chief Justice has already written to the President. Before he decides to dissolve Parliament or not, can the National Assembly or even Parliament itself practice its legislative role in the meantime?
I think it, Trevor, to begin with, the directive by the Chief Justice to dissolve Parliament will be reversed by the High Court. You understand?
Okay, why?
Reversed by the High Court for conflating or altering the process on dissolution. In principle, Parliament has failed and ought to have been dissolved, but not in the manner suggested by the Chief Justice. We have a 12th Parliament now. This is not the offending Parliament, Trevor. The offending Parliament is the 11th Parliament. The Chief Justice missed an opportunity to advise the President as soon as Parliament failed in its role. The Mativo judgment, which is now triggering this advisory, was rendered on 27th March 2017, giving Parliament 60 days, which lapsed on 27th May 2017. The Chief Justice ought to have rendered his advisory immediately thereafter. He failed to do so. His advisory is coming 3 years after. Remember, if you look at Article 261, Subarticle 8, it says, the new Parliament shall have the time specified in the 5th schedule. The Constitution itself creates a distinction between the offending Parliament that ought to be dissolved and the new Parliament, which must then implement the two-thirds gender threshold. Which is why, as Council on Record in Constitutional Petition number 397 of 2017, as soon as the election results were out, we went to court, of course, on behalf of my clients, seeking a fresh advisory from the court. First, a declaration do issue that the composition of Parliament offends the Constitution. Secondly, that there is no justification why the composition of Parliament should offend the Constitution. Thirdly, an order do issue directing Parliament to perfect that unconstitutionality by enacting a law within a period to be specified afresh in that order. Fourthly, that if Parliament fails, the Chief Justice should then advise the President to dissolve the 12th Parliament. Now, there is need for judicial pronouncement before you can dissolve the 12th Parliament. So in principle, the Chief Justice's advice is correct, but in law, it will run into legal challenges because it targets a Parliament that is not the offending Parliament. And it's easy to see that PSC are likely to succeed on their case if they go to the High Court.
And so in the meantime, what does that then mean? It means status quo remains, because there's also a question of if Parliament is legally constituted, then can it endorse or even spearhead changes to the Constitution, like the BBI, for example?
Yes. It can. You see, Parliament is not unconstitutional yet. This Parliament, if you look at the analysis I've given you, this Parliament can continue to function legally until there's a judicial pronouncement relating to its unconstitutionality. Now, what I feel sorry for, the Chief Justice ought to have made an honest admission that 3 years was too long to wait. I was involved in the JSC case where LSK was arguing that the failure by the President to appoint the 41 judges offends the Constitution. In that case, the Attorney General argued that there is no timeline for the President to appoint the judges. So he has not offended the Constitution. There is a definitive finding, Trevor, that a timeline for performing that which the law expects you to perform is 14 days. The Chief Justice failed in his constitutional duty to advise the President within 14 days after Parliament's failure, which means by around 14th of June 2017, the advice coming now ought to have been rendered at that time. Then you would have expected the President to take an identical period of time to dissolve that parliament. Then we would have gone to an election with a new parliament coming in place. The 12th parliament is not the offending parliament. So unless the High Court says that this parliament is the offending parliament, whatever parliament does now, including the laws that they pass, are presumed to be constitutional.
Yeah. So, Joy, how do we get this clarified then? There seems to be an issue of timeline, and you said that the president can actually drag this to the constitution, to the elections in 2022. Can someone go to court to seek clarification of how soon the president needs to act then?
It is a criticism of our constitution that I think we tried to cram too much into it at the same time, such that you get to a place where things like this lapse. So, for example, Steve is talking about the 5th schedule. When you look at the 5th schedule, there's nothing about the gender rule, the timelines to be implemented. So the Supreme Court said, let's do this progressively. And I agree with Steve. The 12th parliament is not the offending parliament. It was the 11th parliament. But there is the principle that was set, because if it was true for the 11th parliament, surely it is true for the 12th parliament. But unfortunately, as the law works, until the declaration is unconstitutional in the case of the 12th, it must remain in office and on the seat until declared otherwise. Be that as it may, like you said, can anybody go to court to have it clarified? The Chief Justice already said he has 6 petitions before him seeking an advisory opinion. What the PSC has done is actually also take the matter to the High Court. And any other aggrieved party can go to the court and seek a declaration on the same. So that's what Steve's clients did last time and were successful at it. The timing was a little bit, the timing was so off, because by the time the judgment was coming, it was sort of overtaken by events. But what the Chief Justice has done is actually what the president is going to do. He sat on this decision, on this advisory for so long because there are no timelines. And just push, because now, as far as I'm concerned, he realizes he's going home in the next 3 months. As far as he's concerned, he's ticking a box of, he's not even interested in whether or not it's going to be acted on. But it has gone on record that he issued the advisory. So as far as I'm concerned, I don't see the crisis, because if I was the president, I would pick the paper and say, you know what, thank you very much for your advisory. And whatever other things people are doing in court or whatever, let me wait for all of them to come. And as the president, I will decide when I'm going to do this. Now, moving forward, maybe a discussion that we need to have is, were we premature in disbanding the implementation of the Constitution Commission, the Nyachai-led one? Were we premature also in trying to let Parliament be its own police in a matter where they were directly affected? Because we are where we are, like I said earlier, because of the failure by the National Assembly to pass legislation to give life to this. Because if the county assemblies are able to have a formula that works gender parity into it, the Senate as well, we elect the 47, we nominate the 16 to try and attain gender parity. What is so difficult with the National Assembly putting their head between their knees and coming up with a solution? It's actually time that this matter was put to bed once and for all.
Okay. Honorable Amalwa, you had mentioned the issue of BBI. How do you think the BBI will solve this then?
Before I come to BBI, Trevor,
the
Chief Justice has been struggling to leave a positive legacy. And that's why in my first remarks I said it was ill-advised, wrong timing, very premature. On October 7th, that is about 2 weeks from now, there is a petition hearing in the High Court to make a determination on Justice Motivo's order of March 2017. And this is to determine whether it is the 11th Parliament or the 12th Parliament. The offending Parliament, we now agree, it is the 11th Parliament, but not the 12th Parliament. CJ's advisory, it is coming at the wrong time. And that's why we're asking, why is he rushing? Is it because he's going to be out of office in the next 12 weeks? And he's not the only person in Jerusalem. He knows the situation in Kenya. So it is in bad faith. And we know very well for BBI to succeed, Parliament must also be there. So for us to succeed in the constitutional amendment, whether it's through the popular initiative, we are waiting for the BBI report. If the BBI report comes as stipulated in, I think, Article 255. If we are going to have any referendum for that matter, the draft bill must be forwarded to IBC. IBC has to forward it to the respective speakers of the respective counties. Upon the debate, if they get a simple majority or whatever the case, they must forward it to Parliament, to both the Senate and the National Assembly. So if at all Parliament is going to be dissolved, even BPI, that is the end of it. Justice Maraga is aware of what is happening in this country. The constitution that was passed in 2010, not everything was good. I've been on record advocating for cabinet secretaries to come from the floor of the House. And that to happen shows you are changing the function of Parliament. It must go through a referendum. We are seeing the two-third gender rule, which is becoming difficult to achieve. It can only be achievable maybe when it comes to appointive positions. And even in appointive position, even the Supreme Court, the way it's constituted, it does not achieve the two-third gender. Our cabinet, which is appointive, it does not achieve the two-third gender. How do you expect elective positions to achieve the two-third gender, and yet you have no control over citizens when it comes to voting? So for BBI to succeed, Parliament must be there. And as my colleagues have clearly put it, we are not illegal. This Parliament is legal until the time His Excellency President Uhuru Muigai Kenyatta dissolves Parliament. That is when it becomes an illegality. I've just emphasized on the critical bills that are on the floor of the House that if National Assembly does not pass within the shortest time frame possible, counties are going to collapse. So I keep asking myself, CJ Maraga, the decisions, why was the rush? We want to wish him well as he goes into retirement. He has done his bit. So let him not struggle to bring a legacy which is not going to be achievable. It is becoming, I don't know how to say it, very disturbing.
And Ogola, there seems to be an interesting perspective there. Why is Parliament the only arm of government that where now the blame squarely lies? I mean, all the other places have not adhered to the two-thirds gender rule, including the appointive positions.
Trevor, that is an unacceptable, chaotic expansion of the scope of the issue at hand. The reason why Parliament ought to be dissolved is because it has a legislative mandate. It has abdicated that mandate. There was a definitive finding on that failure. You cannot revise a court order by saying that, listen, I am not the only person offending the Constitution. We are dealing with Parliament. When we are done with Parliament, there will be a conversation around composition of the Supreme Court, around composition of the LSK, for instance, around composition of other appointed bodies. The issue right now is that there has been a definitive finding by the Supreme Court that the time frame for enactment of the two-third gender law in relation to the composition of Parliament, it wasn't in relation to the composition of all appointed positions. The advisory opinion of 2012, the Attorney General at the then was Professor Githu Muigai, posed the question, as we prepare for election, are we going to implement the two-third gender principle under Article 81B in this election or after the next election? The Supreme Court was of the divided opinion that, listen, this is a principle that undergirds our electoral system, but it need not to be implemented immediately. But then he said, how progressive is progressive? The court made us definitive finding that progressive is progressive only within the meaning of 5 years, which means, and the court was careful to state, if you look at paragraph 79, Trevor, of the advisory opinion that was issued by the Supreme Court, it says, Parliament must then pass the law on composition of the two-third gender principle in Parliament within a period of 5 years, and they said specifically by 27 August 2015. Now, if you want to debate about other organs, then there can be another issue after Parliament has complied. On 27 August 2015, Parliament failed. They then activated a provision in the Constitution that allowed for extension of 1 year in passing laws that implement the Constitution. That that extension expired on 27th August 2016.
Yeah.
Shortly thereafter, the petitioners, the women leaders and activists moved quickly on 16th of September 2016. And it was on that case, we moved the High Court before Justice Mativo, claiming that Parliament has failed in its constitutional duty and that Parliament can no longer waive the sanctity of the Supreme Court advisory, which gave them 5 years. It could no longer waive the sanctity of an extension of 1 year provided for in the Constitution, and therefore Parliament had failed. Justice Mativo, reading the law as he did, he found concurrence with the argument preferred by the petitioners and made finding that he produces provisions of Article 261, which says if Parliament is required to pass a law and it fails to pass that law, then it has offended the Constitution. Then the High Court must specify the period within which Parliament is supposed to make that law. And that if Parliament fails to make the law, then the Chief Justice shall advise. So I've already isolated two issues.
Yeah.
The reason why this Parliament will survive, Trevor, it will survive on a technicality occasioned by the Chief Justice himself. So when I listen to Honorable Chris Wamalwa, I find it mischievous, even outwardly dishonest, to try and expand the scope of the issue without admitting that even this 12th Parliament, knowing the challenges of the two-thirds gender principle at the ballot, knowing the bindingness of the Supreme Court advisory opinion, they ought to move with speed to pass this bill. Now, on 7th of August, the case where I'm cancelled on record is coming up for hearing. That is petition number 397 of 2017. PIDA filed a parallel petition, petition number 41 of 2017. Will those petitions seek to say that, listen, the composition of the 12th Parliament does not comply with the Constitution. And there is no lawful excuse why composition of Parliament does not comply with the Constitution.
Yeah.
Therefore, an order be issued declaring Parliament to be unconstitutional insofar as composition is concerned. But that order be suspended for a period to be declared by the court to give Parliament a time frame to pass that law. Maybe Justice, right now the matter is being heard by Justice Korir. Maybe Justice Korir will give Parliament an identical period of time, 60 days. If Parliament fails to pass the new legislation, let's say by December 2020, then now the Chief Justice may advise the President afresh to dissolve this 12th Parliament. So the point is, bottom line is, for sure, if you look at the Chief Justice advisory, there are serious constitutional and legal questions arising from it because it seems to bind the 12th Parliament without an order declaring that this Parliament has failed.
Okay.
And without an order directing this Parliament to pass that law within a specific time frame. So those are the issues.
Okay.
But in principle, the 12th Parliament, the 11th Parliament, cannot be giving us excuses how other organs of government has failed and Parliament is being bashed all the time. That is not proper at all.
Okay. Ladies and gentlemen, I will take a quick break here. When we come back, we'll take a pulse of the country and hear what the people on the ground, what do the people think about this? Should Parliament be dissolved? Steve Ogola says they will survive on a technicality because they are not the offending Parliament. We'll see it in just a bit. All right, taking a quick break here. Keep your views coming at Trevor Mbija at Citizen TV Kenya. #Daybreak. See you shortly.